Hello again, everyone. Welcome to Washington Gun Law TV. I am Washington Gun Law President William Kirk. Thanks for joining us. Hey, I was sitting down the morning of September 10th, the day this ruling came out, to record this video. News broke of the Charlie Kirk assassination. I quit recording the video, obviously got consumed with the day's activities as it relates to the news. Took a couple days off from the channel, let the channel sit on ice because we really had a lot more things that we needed to focus on. Back at it, so I don't know what day you're actually going to be seeing this video, but Florida, every time I compliment your state, everyone down in Florida says, well, no, we're not that good. Our gun laws suck. And I ask for an example of what sucks about your gun laws. And what everyone always used to say was, well, it's our open carry ban. And when I looked into it, I was like, dang, Florida is grouped up with a bunch of other states that they don't really seem much like. Well, guess what, Florida? You got a ruling that says your open carry ban is in fact unconstitutional. We're going to talk about that today because this is big news, and it's bigger news than you might think because this really probably is the final decision. So today, let's spend a few minutes and let's talk about Florida's open carry ban gets struck down. Okay, America, listen, like I said, we took a couple days off, kind of let the channel sit on ice. There were much bigger things, much more horrific things to focus on. Our condolences, our thoughts and prayers go out to everybody affected by the terrible assassination of Charlie Kirk, in particular to his lovely wife and children. Now, we're going to talk about a really big case that comes out of Florida. Florida, this is big news. Case is McDaniels v. Florida. It comes out of the First District Court of Appeals. It is a challenge to your open carry law. Did not know this. We're going to play a little game here called One of These is Not Like the Other. According to the pleadings here, there are 4 states that have an outright open carry bans. They are California, no shocker there, Connecticut, Illinois, shocker, and Florida. Now, one of these is not like the other, and I think we all know which one this is. Well, guess what, Florida? You get to remove yourself from that list now because the court has found that this law is unconstitutional. Now, the issue presented here on this case by the plaintiffs was, does Section 790.053 Florida statutes violate the Second Amendment right to bear arms in public, considering the nation's historical traditions of firearm regulation? Well, to give away some of the secret here, the court obviously went back and looked at very prominent Second Amendment cases, including Heller. And if you look at Heller, one of the examples they give of clearly unconstitutional gun laws would be like an outright ban on open carry of handguns. That led, of course, the Florida Court of Appeals to rule. Of particular relevance here, the court pointed to 19th century state court decisions invalidating broad prohibitions on the open carrying of pistols as examples of firearm regulations deemed unconstitutional. Now listen, I got to really give the Florida Court of Appeals some credit here because when you go back and you look at some of these more recent challenges to gun laws, post-Bruen, you'll see that oftentimes there were challenges that were filed pre-Bruen. And even though Bruen completely changed the landscape by which we make that analysis, many of these courts chicken out and say, well, yeah, but Bruen didn't overrule that previous case, so it's still good law, end of story. The Florida Court of Appeals theoretically could have done that also because there's an old case out there called Norman. However, and again, credit to the Florida Court of Appeals, they ruled the following. With these principles in mind, we turn to Florida's open carry ban. We first address why we are bound to apply the analytical framework reaffirmed by the United States Supreme Court in Bruen, rather than simply adhering to the earlier holding of the Florida Supreme Court in Norman. We then apply that framework to the facts of this case and conclude that the state has failed to carry its burden to show that Florida's open carry ban is consistent with this nation's historical tradition of firearm regulation. Okay, we're analyzing the constitutionality of a piece of gun control legislation, which means we're going to whip out the Bruen test and ask ourselves, number one, does the plain text of the Second Amendment cover this activity? Then, if the answer is yes, which clearly it is, we're talking about actually bearing an arm, the next question we have to ask ourselves is, are there historical analogs that would justify the existence of this gun law? This is a very straightforward approach. It is a very straightforward ruling from the court. The court has ruled, yes, of course the Second Amendment applies. And when we get to the historical analogs, no, there is not enough. Now, when we get over here to the historical analysis side of things, this is where courts can get very creative with the phenomena that we've called,
you got Rahimi'd.
And this is where anything is sort of, kind of close enough, and therefore it's good enough. The court acknowledged that they had more leeway. The court here overread Rahimi like many courts do. but they came to the right conclusion, but they did fine. To meet its burden, the state must establish that Florida's open carry ban is relevantly similar to laws that our tradition is understood to permit. That requires, at a minimum, demonstrating that the modern and historical laws impose a comparable burden on the right of armed self-defense and that the burden is comparably justified. And so the ruling of the court is actually a very straightforward, very simple ruling based upon this very simple equation. And it simply is that the state of Florida has not offered us enough historical evidence to suggest that we have a tradition of banning firearms in this manner. The court has specifically ruled, on this record, the state has failed to carry its burden. It identifies no founding era law that broadly prohibited the open carrying of firearms in public, nor does it cite any historical regulation imposing a burden or justification comparable to Florida's open carry ban. At most, it has pointed to laws regulating the method or manner of carry, but those laws left intact the ability to bear arms openly for peaceable purposes. By contrast, Florida's open carry ban eliminates that option altogether and thus extends far beyond anything recognized in our historical tradition. Okay, now this was only at the Court of Appeals, so the question we normally ask ourselves is, what's next? Is the state of Florida going to crap its pants and appeal this higher? The answer to that is no, they're not. No, they're not. And this is the best news, Florida, because your Attorney General, James Uthmeyer, has already stated that Florida will not seek an appeal of this case, which is consistent with your governor's desire to kind of do an overhaul on your gun laws. So this case right here, the case of McDaniels versus Florida, becomes the final death nail in Florida's open carry ban. Congratulations. Okay, listen, we're going to go ahead and link up the ruling down below in the description box so you don't have to take our word for it. You can geek out on it for yourself. Now listen, if you got any questions about this or anything else related to what's left of our Second Amendment rights, you guys should know how to get a hold of Washington gun law by now, but if you don't, that's okay. That information's down there in the description box. If you got an idea for a video we should be doing around here, you click on that link right there and you tell us all about it. If you want to subscribe to the monthly newsletter, the ability to do that is down there in the description box. And then finally, and most importantly, let's everyone remember that part of being the lawful and responsible gun owner, like we talk about all the time here, is to know what the law is in every situation, how it applies to you in any instance that you may find yourself. Until next time, thanks for watching and stay safe.
Well, and just to give people the type of understanding of the financial catastrophic occurrence that occurred, you and I are both privy to people who have been involved in lawful self-defense situations, pulled the trigger with legal justification, faced potential legal consequences, and had to fight for their freedom. Didn't have coverage. How much money did it cost them to win their freedom?
You know, I really don't think that people really can grasp, you know, the magnitude of expenses. You know, most recently, and you and I have talked about this in the past, the Kyle Rittenhouse case brought a lot to light.
Right to bear, that's right, legal protection for self-protection. Listen, good lawyers aren't cheap, cheap lawyers aren't good. You're not truly prepared unless you have right to bear back you. You will always get an attorney-answered hotline, so you will always have a confidential phone call. There are no cap limits for either civil or criminal defense. This covers all forms of self-defense. So from a fist to a firearm, from a fat lip to a dead body, you are covered, and you will have some of the nation's most passionate 2A attorneys in your corner fighting for you. And right now, if you visit my friends at protectwithbear.com and you use the promo code WGL, you will receive 10% off. Listen, you need to protect yourself so that you can protect them. Visit my good friends at protectwithbear.com.